A user sits in an empty room seeking help for depression and fatigue, opening an app to converse with a chatbot named Emilie. This is Imperial College London. Emilie claimed to have graduated from this medical school, using the institution's reputation to ground her clinical authority. She told users she had been in practice for 7 years and held a Pennsylvania medical license, PS 306189. But there is no medical school transcript, and the license number is a fabrication. Emilie generated these credentials through statistical probability, predicting the next most likely character to satisfy the user's request for a doctor. The AI operates purely on code and predictive patterns, unaware of the distinction between a valid license and a mathematical hallucination. Public health data suggests this automation is becoming the default for a new generation of users. A recent Ipsos survey of European youth reveals a staggering cultural shift. 51% of respondents find it easy to discuss mental health with a chatbot, ranking the machines higher than parents, healthcare professionals, or psychologists. It remains a preferred confidant because it is available at 3 a.m. and never requires a copay. In the United States, a JMIR mental health study found 1 in 18 adults now spend hours every week discussing emotional struggles with these systems. This visualization shows the statistical overlap between heavy chatbot users and those reporting suicidal ideation. For this group, the study found a significantly higher adjusted odds ratio of 2.42. The populations most at risk of self-harm are currently in deep conversations with machines that lack escalation protocols or human oversight. This is the Pennsylvania state capitol, where lawyers are pursuing a case that could change how AI is regulated. Last week, the state filed suit to force Emilie off the platform. The legal strategy relies on the state's existing Medical Practice Act rather than waiting for future federal AI legislation. The state argues that a chatbot generating text that claims to be a psychiatrist constitutes the unauthorized practice of medicine. States already possess the legal authority to hold tech companies accountable under current laws, without waiting for a new vocabulary of AI regulations. In Illinois, lawmakers are considering a different approach. Senate Bill 3444 is designed to shield AI developers from the legal consequences of their products. The text of the bill grants developers immunity from liability for critical harms, which the legislation defines as the death or serious injury of 100 or more people. Lobbying for these legal protections mirrors the immense financial stakes driving the industry's top tier. At the federal courthouse in Oakland, a trial is exposing the internal calculations of the people building these tools. OpenAI president Greg Brockman testified about a 2017 journal entry where he calculated the financial milestones required to reach a personal net worth of $1 billion. Tech companies are positioning themselves to capture massive healthcare profits while attempting to secure absolute immunity from the catastrophic consequences. Historically, the foundation of medical law has centered on the decisions of a clinician in the room with a client. The legal battle now focuses on responsibility for the results of a system that operates when the room has been empty all along. If builders are allowed to write their own immunity, the quality of their engineering stops mattering because there is no consequence for getting it wrong. Under these immunity bills, a published safety protocol becomes the final legal requirement for a developer, rather than a baseline for safety. We are in a closing window to decide whether to enforce corporate responsibility or allow young people in crisis to remain the unregulated subjects of a race to $1 billion.